Good morning. Are you Mark Marceau?
No.
And Mr. Marceau is charged in cause numbers 26 DCCR 0396 and 0397 with sexual assault of a child, and in 26 0398 with continuous sexual abuse of a young child. And what is the announcement?
Judge, I think where we're at right now is, one thing I do believe we're still waiting on is the CPS records. I haven't received a notification. I checked with Ms. French this morning, and I don't think she has either.
Have they been requested?
Yes,
Yeah.
but there's an order. I think we're just waiting on the court to see it.
I was just looking at, it must be in one of the other cases because I don't see it in 0396.
I believe it would have been in the last cause number is what Ms. French filed the order in.
Gotcha. Double check when that was done. And
That would have been roughly 50, 60 days today.
I signed that order May 22nd. Ms. French, what I'll do is I'm going to reset the case so we can get those. If you can contact Stephanie over there. Usually she's pretty good when we're waiting on something with someone in custody about getting those records to us a little quicker. All right, we'll just do what I'm going to do actually is a 45-day reset, because by the time we get those, you have an opportunity to review them. Hopefully that'll give everybody plenty of time. We can get the announcement at that date.
Yes, ma'am.
Okay,
Thank you, Judge.
I think I forgot. Did we reset Ronald Spites for Mr. Gertz?
Yes.
Okay, it's not about that. Mr. Macon, you have Cyprian Avedantute.
Yeah, Miss French and I have been talking.
Hang on, hold on. Let's get him out. Okay. I'm trying. Yeah. I feel like we've done this before though.
Morning.
Good morning. And tell me how to pronounce your last name again, please.
Avadante.
And Mr. Avedantute, in cause number 23, DCCR 1466, you're charged with unlawful interception or use of electronic communication. And what is the announcement?
Your Honor, Miss French and I have been talking, and she needs a little more time to, I think, get back with me, and I'll evaluate that. I asked for a 30-day reset.
All right, so and I understand that you might have just gotten this recently, but you were hired back in February.
Yes.
So it's time definitely to get something moving on the case. This will be the final reset. You guys get together, visit, and if there's an offer that's acceptable, great. If not, it's time to get this thing set for trial. It's very old. All right, you can go back with bailiff. This will be the last reset for an announcement.
Thank you.
Thank you, Judge.
Good morning, sir. Are you Scott Harmon? I'm sorry, Samuel Harmon. And Mr. Harmon has two cases, cause numbers 25 DCCR 1019 and 26 DCCR 0385, set for trial to begin with jury selection next Monday. And what is the announcement?
Yeah, I am kind of going to announce not ready. I was just hired. I know that it's been, you have a previous attorney. When I got hired, I realized that there were mental health records from the jail, and also when he was in the free world, and some videos I haven't. So, I mean, I guess if you get in a jam, but
No, well, let me ask you this. If I reset it off the trial docket do you anticipate it still going to trial? You still need that information, or do you want me to put it maybe on a status and then we see, since you just got hired?
I'm sorry, Judge. I would ask for a status because depending on what the records and mental health evaluations are, then I know that Mr. Nichols is in trial this week. And last week I was out of pocket. So yeah, I would
Okay.
ask for a status.
So what I'm going to do is reset the two cases off the trial docket onto a status in about 30 days, give you some time to kind of get caught up, get that information to Mr. Nichols, and we'll see where we go from there. Mr. Nichols?
That should be fine.
Good. Okay, perfect. All right, you can go back with the bailiff, sir. Yes, sir. You also got Relacia Mouton.
And we signed up.
Oh, I see.
going through.
Okay.
Are you ready for her?
Yes,
Okay, I just need her just signatures.
yeah, go ahead. And how many are coming through?
I have 3 and 2 of them are being dismissed.
Okay.
All paperwork's been sent to the clerk. Right here. You know, right.
Thank you, Mel. Good morning, ma'am. Are you Relacia Mouton?
That's right.
And Mr. Burbank, will your client waive the formal reading of the indictments in each of the cases?
Sure will, Your Honor.
Before we go forward, I'm also going to take judicial notice in all of the court's files on Ms. Mouton. Ms. Mouton was examined for competency to stand trial by Dr. Capon. I received that report dated July 21st of 2026. The finding after that examination was that Ms. Mouton was competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor, I've received the report. I would say for the record that through my representation of Ms. Mouton, she has answered all my questions. She understands the proceedings. So I feel confident to move on with this plea agreement.
Thank you. Anything else from the state?
From the state.
Then based on that information from Mr. Burbank, as well as the report, I am going to find that Ms. Mouton is currently competent to stand trial. We going on count
We can go with count.
one only, at least in the first one?
And all of them.
All of them, okay. Get that pulled
There
up.
are 2 second degrees and 1 state jail.
Okay. Ms. Mouton, in cause number 25, DCCR 0907, the state has elected to proceed on count 1 only. It alleges that you committed the second-degree felony offense of assault on a peace officer, and that was from May 2nd of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
Sorry, I've got to get it pulled up the right way in each of the cases to make those notations. Now, in cause number 25, DCCR 1466, the state has also elected to proceed on count 1 only. It alleges again that you committed the second-degree felony offense of assault on a peace officer from August 17th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
And then finally, in cause number 25, DCCR 1467, you're charged with the state jail felony offense of possession of a controlled substance from August 17th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
In all 3 of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand it?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection, states 1 in each case, Your Honor.
It's admitted in each case. All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Again, make that finding that you're mentally competent and you understand the nature and the consequences of your pleas. And cause number 25 DCCR 0907 finds sufficient evidence to find you guilty. And at this time, finds you guilty of the second-degree felony offense of assault on a peace officer. Sentence you in accordance with that agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 251466 also finds sufficient evidence to find you guilty, and at this time finds you guilty of assault on a peace officer. Sentence you in accordance with that agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You'll also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in 251467, find sufficient evidence to find you guilty, and at this time finds you guilty of possession of a controlled substance, a state jail felony. Sentence you in accordance with your agreement to a term of 20 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 3 cases will run concurrently, which means together at the same time. I'm also going to sign dismissals as part of this agreement, and cause numbers 25 DCCR 1468 and 26 DCCR 0120. I've handed you the trial court certifications in each of your cases that shows that these were agreements and I did follow them, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank. All right, good luck to you, ma'am. Thank you.
I'd be excused. Judge.
Yes, sir. Thank you, Mr. Burbank. Oh, no. The one she's resetting, we don't even need that long, just a week or 2. Yeah. I did, but we didn't talk to Mr. Parker about that. And he actually has an appointment that he cannot miss in a little bit. So that's okay. Tell her not to worry. We reset it.
Oh, okay.
We had to. Mr. Parker had to leave.
Okay, I'll let her know.
Yeah, I didn't realize that. We should have included him in those discussions and did not. And I know she has some witnesses, so probably the sooner the better for her to let them know what happened. Thank you very much.
Let you know. Hey, Tom.
Have you already told her? Taking care of your people, so you wouldn't have to.
Mr. Rojas, you've got Sarah Jordan.
Can we hold that one?
Sure. Okay. And then you've got Jalen Hendricks. It's a bond hearing.
We need Hendricks.
Yes, please, sir.
Yeah. No.
Good morning. How are you?
Good, how are you?
Good.
Yeah.
Charlotte, I've got somebody out. Oh.
Up front.
I'm printing an administrative hearing just so I can read it better on this one. Good morning. Are you Jalen Hendricks?
Good morning as well.
And this is cause numbers 23 DCCR 2323. In that case, Mr. Hendricks is on probation for evading arrest or detention with the use of a vehicle. A first amended motion to revoke probation has been filed in that case. And then we also have 25 DCCR 0574. Mr. Hendricks is also on probation in that case for evading arrest or detention with the use of a vehicle. And there is a first amended motion to revoke community supervision in that case as well. Mr. Rojas has filed motions asking that bonds are set in both of those cases. And Mr. Rojas, do you intend to call your client?
I do, Your Honor.
Mr. Hendricks, the best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You may proceed. Go ahead.
You're Jalen Hendricks, right?
Yes, sir.
Jalen, where were you born?
Jefferson County.
Have you lived in Jefferson County your whole life?
Moved around from group home to group home.
When was that? Is that because you were in CPS care?
Yes, sir.
Have you ever lived outside of Jefferson County?
Yes, sir.
Okay, where was that at?
Houston, Dallas, Power, Texas. I came back to Beaumont at 17.
Speak up, please.
Houston, Tyler, Texas, Dallas. Then I came back to Beaumont at 17.
Thank you.
And all those other places that you lived, that was because you were moved around through CPS care, is that right?
Yes, sir.
Your only family is here locally in Jefferson County, is that right?
Yes, sir.
And that's your grandmother?
Yes, sir.
You don't have any other family, do you?
No, sir.
I think you told me you have a fiance though?
Yes, sir.
Okay, what is her name?
Jasmine Briscoe.
Jasmine Briscoe. Do you own any property that you could sell? A house, a car, land, a boat, trailer, anything like that?
No, sir.
Okay. Do you have a bank account?
Joint bank account.
A joint bank account with who?
My grandma.
Okay, and do you know how much money, about how much money is in that bank account?
1,000.
About $1,000. And do you put money in that account? Does your grandmother put money in the account?
You all do.
You both do. And where did you get your money from that goes into that account?
Social Security.
And is your grandmother working right now?
No, sir.
Okay, where does she get her money from?
Social Security.
So, you're asking the judge to set a bond this morning. How long have you been in jail right now?
Since August 5th.
And you're on probation for 2 felonies. And before you got placed on probation, you were sitting that time out in jail, weren't you? You were waiting in jail to get probation.
Yes, sir.
And so is it due to the fact that you think you may have $1,000 in the bank? And how much do you get a month for your Social Security?
About $200.
$1,200?
Yes, sir.
Okay. Is it realistically, how much money do you think you and your grandmother and your fiance could come up with in order to make a bond?
2 or 3.
2 or 3 what? About $2,000 or $3,000? Okay. And so are you asking the court to set your bond somewhere in the neighborhood of $20,000?
If she allows me.
Okay. Now, do you have the $2,000 or $3,000 with you right, or do you guys have that right now, or do you have to wait a little bit more time to come up to save that money?
I have to save a little bit.
Okay, so even if she were to set the bond at $20,000, you wouldn't be able to get out today, but hopefully in maybe a few weeks, your grandmother would be able to have that money.
Yes, sir.
Pass witness. No questions.
All right, thank you. Any other witnesses?
No, yeah.
Mr. Smith, what is the state's position?
Judge, he's not entitled to a bond because these are both straight probations. These were not my cases. These were Mr. Coleman's that transferred to me after he left the court. Spoke with his probation officer, and she is here if you have questions for her, Judge, but seems like he does report regularly, and I think he tries to pay fees as he can, but everything else he just doesn't. He got kicked out of immoral recognition therapy twice.
What's the status of the new assault? We're talking about this.
I think it's filed. They're just carrying along with this case.
I mean, he's talking about this female, like they're together, but there's a a
I'm
bond
sure there's gonna be a
condition that he
bond
have no condition, that no contact with her, because that's an allegation in this motion.
If I, does, Ms. Briscoe, does she live with your grandmother or does she have her own house?
She got her own house.
Okay, now you understand that if you were to be released on bond, that one of the conditions, probably in this case, but for sure in the misdemeanor case would be that you don't have any contact.
That's fine.
And you're telling the judge you would stay away from her?
Can you double check? Let me hold this for a second, what the status of that is down the hall, so, have a better idea. Just have a seat over there for a second, or wherever the bailiff wants you. I'm gonna recall your cases in just a minute.
Yes, ma'am.
Justice Larzo,
Just can we hold that one also?
sure. What about Trayvon?
I'm ready.
Trayvon Patterson?
Ready on that one. That's gonna give at least some things.
Where's the one?
Good morning. Are you Trayvon Patterson?
Yes, ma'am.
Mr. Rojas, will your client waive the formal reading of the indictment?
Here we are.
Mr. Patterson, in cause number 26 DCCR 0521, you're charged with the third-degree felony offense of obstruction or retaliation from March 4th of 2026. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you
Yes.
with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Now, it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Patterson's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do a pre-sentence report. And that'll just give me more information about you and your case, and we'll come back later for sentencing. Mr. Nichols, what is the state's position with regard to bond reduction based on that plea agreement?
She has no other criminal history, and Ms. Mofino made a lower range offer, so I think there's no reason not to.
So, Mr. Patterson, what I'm going to do based on the nature of that agreement is reduce your bond today to $1,000. I'm going to make that a personal bond. That means you're not going to have to pay any money. You're just going to get released from jail, but there's several very important things about that.
Yes, ma'am.
So first thing is that as soon as you're released, you go straight to the probation department. You're going to get some documentation today before you leave that tells you where to go, but you've got to go get that process started so that they can do that report for me.
Yes, ma'am.
If you don't do that, then you run the risk of me not accepting the plea agreement. Things could be worse. You understand? Also, if you're arrested for anything between now and when you come back for sentencing, you run the risk of me not accepting the plea agreement. You understand?
Yes.
All right, we'll see you back at sentencing.
This hearing shows how a plea agreement can come with very specific conditions. Gregory Barnum entered a guilty plea to the charge discussed in court, and the judge explained that the agreement included deferred probation, a fine, and strict probation requirements. The court then reduced his bond to a personal bond, meaning he could potentially be released without paying the full bond amount up front. However, the judge made the expectations very clear. He had to report directly to probation after release, return to court for sentencing, and have no direct or indirect contact with the protected individual. The judge emphasized that failing to follow those conditions could put the entire agreement at risk. It was a clear reminder that a reduced bond does not mean the case is over. The defendant still has important responsibilities to fulfill before the final sentencing.
Right, are you Jamie Story?
Yes, ma'am.
And Ms. Story is currently on probation and cause number 23 DCCR 1546 for, well, it's a state jail felony offense of theft of property, but it was enhanced back at the plea, I believe, to a second degree felony offense. There was a motion to adjudicate file. We were here. Ms. Story entered pleas of true to counts 1 through 7. I've received the updated report. Have you both had an opportunity to review that report?
We have, Your Honor.
I have, Judge.
Any additions or corrections to the report?
No, Your Honor.
Only addition I would have is new deference to Ms. Lopez's comments.
Good morning, Ms. Lopez, and I've gotten your updated report. Is there anything that you would like to add to that?
No, ma'am, not at this time.
Okay, thank you. Mr. Rojas, you may proceed.
Yeah, Judge, Ms. Story's here this morning. She realized that she was already given 1 second chance on probation and she was sent to ISF. Completed that, was released. She was depending on her stepfather as a support system in her ride. Her stepfather died. She passed away, didn't have any transportation. She lived, I think, in Liberty at that time. She didn't have transportation, missed the first appointment, and then, like so many other people do, she got scared and started thinking she was going to be in trouble for not reporting, and it just snowballed from there. She stopped reporting. Again, her stepfather has passed away. He was her only support system. She realizes that probation is probably not going to be an option for her. We're asking the court to consider those circumstances and sentence her somewhere in the lower end of the range, possibly 3 years. I think Ms. Story would like to say something at the appropriate time.
I just want to apologize for, disrespecting you by not abiding by your rules. You didn't.
Ms. Malfino?
Judge, I certainly appreciate that statement to the court, and especially no disrespect to you, Your Honor, but to Ms. Lopez, who has basically been chasing her around for years. I don't think it's fair for me to stand up here and argue for a lot of pen time. Honestly, the offer in the very beginning was a year state jail, which she turned down in order to try to get an opportunity at probation, which you gave her, and then obviously she has done absolutely nothing. So I will defer to whatever punishment you think is appropriate.
Ms. Story, you getting this probation in the first place. I'm looking back at the original pre-sentence report. This case was your 6th felony, and you got an opportunity at probation. Then you got opportunities while you were on probation. So it really is kind of a slap in the face to myself, Ms. Lopez, and everyone who tried to help you. I understand, needing a support system, but also you're how old at this time? Almost 50 or 40? 45, sorry. I was looking back at the old pre-sentence report. Anyway, it's just at some point you've got to rely on yourself to do better for yourself. I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence at this time to revoke your probation, and at this time revoke your probation. Reassess your punishment to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. I think we already went over that before when you were initially sentenced about you not being eligible to possess a firearm or ammunition. If you have any other questions about that, you've got that document to read. Also, you can ask Mr. Rojas. All right, Galati, ma'am, you can go back with the bailiff. Did you get some information on Jalen Hendricks, Mr. Nichols? Well, who was looking, Mr. Smith?
No, not Hendricks. I was looking at something. I did look at Mr. Hendricks.
Okay, Mr. Hendricks, come back up, please. Hold on. Thanks. All right, we're back on with Jalen Hendricks, and what did you find out about that? I'm sorry.
The case is pending. It's in Judge Wood's court, and his next setting is a jail docket in there, September 25th.
All right, so any other evidence or argument with regard to setting bonds in these cases?
No, Judge, just to point out that I think these are his only felonies that he's ever had. He's got limited misdemeanor history, but I think these are his only felonies. So,
Mr. Smith, anything else?
No, Judge.
So, Mr. Hendricks, the problem I have is, well, a couple things, but first of all, it looks like you were placed on probation December of 2025 for 2 evading arrest. So you had one from back in 23, while you're on bond, you get another one, and you get this opportunity at probation. And then we've got a new offense, and we've got the fact that you just cannot seem to follow through with at least this MRT class and some other things on your probations.
I guess a couple other things, Judge. Probation brought to my attention the fact that the address they have for him is actually the apartment where the victim does live. So he was living with her at the time. There's also an emergency magistrate protective order that's good for at least 90 days. It prevents him from roaming around her for 90 days on top of the bond conditions that you have set. So he did it, I believe, say that he was living with his grandmother, that he was living with her until he went to jail. Living with the victim, not the grandmother.
Oh.
Mhm.
Back and forth. Grandma, stand with her.
After you were arrested for the assault on her. So after you were arrested for the assault on her, were you still going back and forth after that?
No,
Okay. I'm just checking what those original bonds was then. Okay. What's the address? Her address?
on 105 Training Groves.
Is that the address you have?
7110 Highway 105. 7110.
That's an apartment complex.
That's
Yeah.
where the complaining witness in the 7110.
Highway 105, apartment 725. Right.
That Beaumont?
Yes.
What's her name again?
Jasmine Briscoe.
Jasmine?
Jasmine.
Jaslyn. How do we spell that?
JAZZLY.
Briscoe?
Yes, ma'am.
Do y'all have any children together? What?
One
Who takes care of that child? Is it with her or somebody else?
with her. Both of us sister.
What's your grandmother's address?
On 190 Toledo Street.
Okay, what I'm going to do in cause number 23 DCCR 2323, grant the motion to set a bond, and at this time. Well, let me look back at something. So were there any issues? Any positive drug screens?
Yes, when he got arrested in office, he tested positive for THC.
Right, I'm going to deny both of the motions at this time to set bonds. I don't think it is proper on probation for 2 felonies. We've got a new allegation of a serious offense. Got positive drug screens, failing to follow through with the therapy. I think they're probably, if there's going to be a continuation of probation, needs to be something a little more intensive if we even consider that. All right, you can go back with the bailiff. Mr. Roadhouse will be out there to visit with you, tell you what your options are.
The most significant moment here comes during Jalen Hendricks' bond hearing. The defense presented information about his background, financial situation, family support, and time already spent in custody while asking the court to consider setting a bond. The state, however, pointed to several concerns, including his existing probation on 2 felony cases, alleged violations of probation requirements, a new pending allegation, and concerns involving compliance with treatment. The judge carefully reviewed those circumstances before making the decision. Ultimately, the court denied the motions to set bonds at that time, explaining that the combination of the existing probation cases and the additional concerns made release inappropriate under the circumstances. The hearing demonstrates how a judge can weigh personal circumstances against the broader record when deciding whether release is appropriate.